Good morning again. Our next speaker, Grace Maitland-Carter, as appears from her CV in the book, is an assessment officer of some standing, and she's going to speak to us today on a view from the assessment office, or as someone has subtitled it, In the Lion's Den.
Yes, I blocked that title actually from my mind, so I have to say, Solicitor Client Assessment, a view from the assessment office. We hope we're not that scary. In this paper, I intend to highlight some aspects of the practice and procedures of assessment of costs on a solicitor-client basis pursuant to the Solicitors Act. I propose to approach this topic in a pragmatic manner, possibly to be helpful to a solicitor on appearances before the assessment court. Oh, sir. Can you hear me? Is this closer? Is that better? The assessment officer. To those who do not know, an assessment officer hears everything in the same way as any other trial judge does. Our position is very much like that of a master in that we have to hear the evidence pertaining to the issues, and our decision is based on the evidence that we hear. The quantum of claims in dispute frequently reach into the hundreds of thousands of dollars. It is not unusual for the client appearing on the assessment to be unrepresented by counsel, and the assessment often takes place in strained and emotional circumstances. On the other hand, when both sides are represented by experienced and aggressive counsel, the assessment takes place in a more professional manner and usually tests the evidence and the position of the solicitor to justify his or her account in a more thorough manner. When the evidence comes out at the hearing and various factors are considered in light of the evidence, sometimes the fees are reduced. Now, it seems to be a common view of the public today, and many lawyers in practice, that the fees will always be reduced. I think it's safe to say that in approximately 1,000 cases that I've heard since starting about 3.5 years ago, many of the accounts are not reduced, and the perception of the public, unfortunately, is based on newspaper articles that just highlight very extreme situations sometimes. Obtaining appointments for assessment. Now, this is a very important subject, because if most law firms send their clerks or service people to get these appointments, if they are not aware of what's going on at the assessment office now, the appointment that you obtain will perhaps play a key part in you not being able to get your assessment hearing for months and months, perhaps even years of delay. Many of you are aware of the difficulty in obtaining dates for assessment hearings. There are presently 5 assessment officers, of whom Mr. McNeil is retiring and Mr. Gramlow has resigned and is just now finishing off his list. That will leave 3 assessment officers probably towards the end of the summer. The scheduling, I'm advised, is now being done for October 1997, and the dates quickly being taken up. There is also now an A list and a B list. Many of you may not be aware that the A list matters take priority. The B-list matters will only go on if an A-list matter does not appear or is dealt with quickly. solicitors can only be certain that a matter will proceed if it is scheduled on the A list. Now, this is very significant. I'll just give you my experience yesterday. I had a matter, half-day matter, scheduled on the A list. At 2 p.m., I had three half-hour, 1-hour matters scheduled on the A list. Also, on the B list, there was a matter scheduled for 1 full day. Now, the matter on the B list involved $101,000. There were 4 solicitors involved. 2 had come from British Columbia. 2 were from British Columbia. 1 was from the United States. The client, I don't know if I think the client was unrepresented, but his counsel was from Toronto. They all showed up. Now, luckily Mr. Gramlow's matter was settled and he could hear this matter, but if that hadn't been the case, these people would have been turned away. They would have come for nothing, and I think it's very important when a solicitor obtains an appointment to ensure that you're on the A list. If you know you're on the B list and you have several witnesses and you have to schedule people from out of town, it can be very upsetting to everyone. So that's something that you should all be aware of. The assessment offices is doing this scheduling. The assessment officers are not in favor of it, but there's nothing that we can do. The only thing we can do is when we are seized of a matter and we can't finish, we give you endorsements, at least I do, to reschedule the matter on an A list. This will hopefully ensure that this matter does not, you don't come back for nothing on another day. Mr. Upenieks spoke about giving yourself enough time. My advice to you is to schedule enough time to finish the entire assessment in 1 block of time, whether it be 1 full day or 2 days if possible. Usually, if the account is over $20,000 and several witnesses are scheduled, 1 full day at least is generally required. Unfortunately, even with smaller accounts, sometimes the evidence and number of witnesses result in the matter not being concluded in the time allotted, and the matter then must be rescheduled for a further day or half day for completion. The assessment officer will not arrange for new dates, and the applicant must return to the court office excuse me, at 393 University to reschedule. Once you have obtained the appointment, my advice is to serve the client as soon as possible. Don't sit on the appointment for 3 months and then serve the client at the last minute. This always results in complaints before the assessment officer, and this will gain sympathy for the other side because, as Mr. Upenieks pointed out, there isn't discovery. There are no brief of documents prepared. There's nothing, so that if the other side comes with very little notice, very little information, and they ask for an adjournment, they have a very good chance of getting it. Provide the client with a photocopy of the dockets or docket information that may help narrow the issues and shorten the hearing considerably. Where a solicitor has gone out of his or her way to provide a client with all the information reasonably required at the hearing, I'm generally of the view that it would be unfair to the solicitor to grant a client an adjournment for reasons that appear more related to an attempt to delay. A copy of the order, the appointment, and the docket material should be served. It is also prudent, as Mr. Upenieks pointed out this morning, to serve a notice under the Evidence Act if business records such as the dockets are to be relied on at the assessment. This could be important if some of the work done on the file was done by a solicitor who is no longer with the firm. Obviously, if a significant part of the work was done by various persons, they should attend the hearing, or there is a risk of not being able to prove that aspect of the account adequately. The hearing. I'm amazed how often solicitors who attend assessment hearings for the purpose of proving their account do not adequately prepare their evidence. It saves a great deal of time and if the solicitors present him or herself in a professional manner to the court. And Mr. Orkin has discussed this also. As a preliminary matter, the solicitor should file an accurate summary of the total bill of costs, setting out all the accounts to be assessed and a breakdown of fees, disbursements, and GST, and payments made to date by the client. The assessment officer will not care to see the solicitor's calculations of interest at this point in time. And Mr. Upenieks spoke about having your spreadsheet. I think that was your point, Mr. Orkin. If you have a morning book for an assessment, when you think about it, that's only 2 hours. If you spend 20 minutes at the beginning of the assessment trying to sort out the math, the total of all the bills, what's been paid, what's not paid, it's almost, you could spend half of your morning just doing that. So in the interest of really expediting the matter, these simple things should be done by your law clerk or anyone, your bookkeeper, and just have a spreadsheet, something that we can quickly reference and go on with that matter. I don't know if any of you have seen our certificate, report and certificate. The first number on that certificate, when my paper is ready, I'll include a sample certificate. The first number is the total bill of costs. We must know what that is, and we should know at the beginning of the hearing. And if we have that in a brief, even a simple spreadsheet, anything from you, it saves a lot of time. The service. The solicitor must also file the proper affidavit of service. The court must be satisfied if the client does not, particularly if the client does not appear, that there was due notice of the assessment date, the time and place given to the client. I think I can advise you on behalf of all the assessment officers that our view is that service should be done by personal service or registered mail. Occasionally substituted service, of course, if it's impossible to find the client. If ordinary mail is used, the solicitor should have written, or even better, spoken to the client by telephone. The solicitor can then advise the court under oath that the client had received the appointment and was well aware of the hearing. The hearing can then proceed ex parte. If the client is represented by counsel, it is always helpful to the process if the solicitors have had preliminary discussions before the hearing with a view to settling the matter. At the very least, this process might help narrow the issues and save time at the hearing. The solicitor's evidence goes first, as he or she must prove his or her account. Your evidence, after a brief introduction outlining your qualifications and expertise, should be succinctly presented as a chronology of the work done. When assessing the account, the assessment officer reviews all the evidence, giving particular consideration to the 9 factors approved by the Court of Appeal in Ray Cohn and Keeley and Blaney, 1985, 26 CPC, 2nd edition, page 211, as follows. 1, the time expended by the solicitor. 2, the legal complexity of the matters dealt with. 3, the degree of responsibility assumed by the solicitor. 4, the monetary value of the matters in issue. 5, the importance of the matters to the client. 6, the degree of skill and competence demonstrated by the solicitor. 7, the results achieved. 8, the ability of the client to pay. And 9, the expectation of the client as to the amount of the fee. It may be prudent for the solicitor to incorporate these 9 factors in his or her presentation. However, having said that, there is a 10th and very important factor, and that is credibility. An assessment officer, when considering the evidence, must place a heavier onus on the solicitor, as the solicitor-client relationship is one of trust and reliance between a professional and a non-professional. My advice to solicitors is that when running a file, they should make a practice of sending out timely, detailed interim accounts. They should write letters to clients to confirm understandings with respect to fees, and also do memos to file documenting meetings and relevant conversations with clients. Now, I'll briefly touch on the issue of retainer. Mr. Spiegel's article actually was a very good review of the subject of retainer. There are a few parts of it that perhaps we could discuss in question period that give me a few concerns. I would like to briefly touch on this issue. The best advice with respect to retainer from an assessment officer's point of view is that there should be a clear and specific agreement which sets out all the rates, areas of responsibility within the parameters of the retainer agreement in a comprehensible fashion which the client can understand. Our view is that it is the responsibility of the solicitor to ensure that the client did in fact understand the nature of the agreement to which he or she was signing. Oral agreements are generally vague and not satisfactory. The retainer issue is generally evaluated under the factor responsibility assumed by the client. And where it appears that the solicitor has had ample opportunity to properly deal with this issue and did not, generally there will be a reduction to the account. The retainer agreement should include rates per hour charged by individuals who worked on the file. But a note of caution, in an assessment, it does not necessarily mean that all fees charged will be allowed, as there may be duplication of time spent. Now, just to give you a few examples that may be helpful to solicitors in larger firms. It's not unusual for at an assessment hearing to see matters being handled at large firms by several legal personnel working on the file, and whether everyone's docketing for meetings or conferences or whatever. And sometimes 2 solicitors will both attend a court on behalf of the client, and that may be fine if the client is aware of it and agrees to it. But sometimes clients don't understand that by signing these very complicated retainer agreements, they're effectively allowing for a potential hourly fee of perhaps $8, $9, $1,000 an hour. And when this comes up before an assessment officer, and the client says, "Well, yes, I signed that retainer agreement, but I never understood that these people would be all working at the same time, and that these are the kinds of rates I'd be paying." Now, Mr. Spiegel's article talks about independent legal advice, and I think this is a good example of where the client, if the retainer agreement is that complex, then perhaps the client should have retained independent legal advice and had this better explained to them. They may not have agreed that that's the kind of hourly rate that would be acceptable to them. And it's better to have that cleared up beforehand than later at an assessment hearing. The issue of docketed time. Here, there is rarely a dispute that the time docketed was actually spent. The dispute is often whether the time spent was excessive in relationship to the result obtained. The time docketed by other solicitors who worked on the file cannot always be supported as valuable to the client if these solicitors do not attend to give viva voce evidence. Sometimes, if a senior solicitor responsible for carriage of the file attends, and the dockets are filed as business records under the Evidence Act, it could be of some assistance to proving the accounts of other staff who do not attend. Also, as mentioned above, to be considered in a review of the dockets is excessive time billed to the client with respect to preparation, internal staff meetings, changing solicitors working on the file, and review. Solicitors should be aware that the assessment court takes a dim view of duplication resulting in excessive time being charged to the client with respect to the above issues. Although dockets are not required to prove your account, proper dockets can be an excellent tool to use when presenting your case, providing A, the dockets are accurate and identifies the solicitor working on the file, B, indicates rates per hour charged, C, indicates type of work performed and time spent, and D, dockets should be recorded contemporaneously. Reconstructed dockets for the purpose of an assessment hearing run the risk of not being allowed to be used as evidence, or if allowed, usually becomes suspect. Often these dockets do not stand up under cross-examination and actually become a liability in proving your account. Interim billing. As I said, interim billing is a recommended practice as it gives the client an understanding of how the fees are mounting and the opportunity to assess the situation. In cases where interim bills have been rendered and a full explanation made as to how a solicitor's account would be arrived at, it is not open to the client at the end of the action to claim that he or she was surprised or misled. Now, I'd like to touch on this concept of the series of bills, the global assessment, and what bills would be allowed. In order for an assessment to take place, we require the proper authority of a precipice order from the registrar under Section 2 of the Solicitors Act, an order of the justice, or an assessment may be by order authority of a statute, for example, Section 24 of the Motor Vehicle Act. If a solicitor takes out the order, she or he will generally include for assessment only unpaid accounts. Now, Mr. Upenieks mentioned put in all your accounts. That may be a good practice. Sometimes it's not necessary. I think that it's difficult sometimes for solicitors. I think in the family law bar, the nature of that sort of retainer is that there can be intense activity on a file at the beginning of the file, and it always leads to some conclusion, whether it's a separation agreement or divorce, whatever. The account is rendered, the account is paid, the client generally is happy with the account, there's no application for assessment or whatever. Then perhaps after 6 months or a year goes by, the other side applies for a variation. The solicitor is approached by the client. The solicitor does work on behalf of the client, renders another bill. This is not paid. The solicitor sets the matter down for assessment. At this point in time, the client brings all the bills, whether they go back 3 years, 2 years, whatever, and says, look, I paid this solicitor $50,000 for my divorce, and he or she hasn't done anything for me. I don't know if the solicitor, I think the solicitor was probably correct in not bringing in all the bills for that assessment at that point in time. However, once the client does that, then the solicitor can either do one of two things. Can agree to include them all. The assessment officer has the authority to amend the order to include all the accounts, or the assessment can be adjourned to allow the parties to go before a justice for an order, whether these accounts be included or not. The question is, were these accounts interim? In my view, often they are not interim accounts, but they are they were final accounts or accounts in another matter that were paid. And if solicitors are concerned about that, it may be prudent for them to really send out final accounts, final letters, close files, and open new files. And then if a new matter comes up 2 years later, that may be a way of obviating this sort of thing happening. Now, I have a few cases I'd like to refer you to, and these would just be under general comments. The case of Ray Kruger and Gavertney is a decision of Mr. Justice Anderson, a 1981 decision. I'll have the citation in my notes, in which he states, the fee must be proportional to the amount at issue in the litigation or the amount recovered. He says, and this was on appeal from an assessment, a gross disproportion between one and the other is indicative of an error in principle. This decision comes up sometimes when we typically see personal injury litigation matter, and the amount that the client would receive sometimes is $10,000, for instance, and the lawyer's fees could be 20, 25, 30. Litigation, personal injury litigation, is no different, in our view, from any other kind of service rendered by a solicitor. When this kind of bill comes before us, we evaluate it in the same way, the same factors. There is no magic to the fact that an insurance company is involved. Once it's before the assessment officer, we have to look at it the way we look at any other matter, and solicitors who specialize in that kind of law should be aware that it's a party assessment has parameters for that kind of assessment, but for a solicitor-client assessment, that goes way beyond the parameters of what documents were filed, what documents were prepared, and we have a much broader scope. And the assessment process, the solicitor and client assessment process, is not a party and party assessment, and they should be aware that concept of proportionality could come into play. Now, we touched on research this morning, and often we see a lot of research on a file, and sometimes this research is allowed, sometimes all of it is allowed, sometimes some of it is allowed, sometimes none of it is allowed. I'd like to refer you to the case of Chang Cairns versus 601039 Ontario Limited. It was Justice Salhani who in St. Catharines, this is one of Mr. Gramlow's favorite judges. Finally, I have some difficulty with Mr. Donegan's submission that the solicitor should be entitled to charge the client for research of the law. I recognize that the law has become very complicated because of the proliferation of statute law and judicial authorities. Nevertheless, a client who retains a solicitor of many years' experience and who is prepared to pay for that solicitor's higher hourly rates because of that experience is entitled to assume that the solicitor will be aware of all the relevant law. Indeed, the client makes a decision to pay a higher hourly rate because he assumes that the solicitor has that special expertise and knows the law. To charge the client on top of that a fee for researching the law flies in the face of the reason the solicitor was chosen. Ironically, although the ordinary citizen is presumed to know the law, solicitors appear to be the only persons in society who can charge a client for that ignorance. I recognize that it is the practice of taxing officers to allow charges for legal research. In my view, it should not be an automatic allowance. It should only be allowed in unusual cases for the reasons which I have already given. I would doubt very much if a client would be prepared to pay a higher hourly rate to an experienced solicitor on the basis of that experience, only to find that the solicitor is also charging him to do research. And just to add to that, if you have students, junior solicitors who are doing research on a matter, the question, and there may be a fine line, how much of this research was required for the client's interest, and how much of it should be allocated as a learning experience to that student or junior solicitor? And you'll find that the assessment officer will be interested in knowing that, and will put the question to you, and you should be prepared to deal with that. Now, the other items of interest. Now, interest is allowed on an account pursuant to the Solicitors Act. I refer you to Section 33(1) of that, and you should know that section and be familiar with it. And I like Mr. Upenieks' idea about having some sort of calculation in your mind, having done some sort of work, and having your calculator there. I often, when I ask solicitors, even when their account is allowed in full, do they have any submissions with respect to interest? They say they would like interest, but it would be helpful if they had that figure at their fingertips, or we could quickly figure it out if they have a calculator. And luckily, some of the court reporters are very good in math, so they're helpful. But it's very unprofessional in our view to not be prepared for these submissions, which you know are coming. Hopefully, if you are successful. The last matter, perhaps you'll have questions. Costs of the assessment. A recent appeal decision Ray R. Lauren Carrier versus Melvin Turner. This is a Newmarket file, an assessment file, Cloac J, deals with the issue of costs. And this is an important case because it basically indicates that no costs are given to the solicitor if they represent themselves for preparation or time spent at the assessment hearing. Now, I have given solicitors costs representing themselves, and this is when, in our view, the application by the client was frivolous or unjustified, and the evidence supports this finding, and costs are within the total discretion of the assessment officer. But I do bring it to your attention that solicitors, if they act as their own counsel, should not automatically expect to be indemnified for a counsel fee when there's no need for it, especially when they're seeking to collect their own accounts. After reviewing my assessment record book, it appears that in approximately 3.5 years, I have presided at almost 1,000 assessments. And I must tell you how often during these assessments I have felt that the solicitors have done a better job for their clients than they have done for themselves. Busy solicitors will often not spend what they view as extra time, which, by the way, should not be charged to the client, to send letters to their clients or write memos to file with respect to solicitors' fees. However, such a practice would only stand you in good stead later at an assessment hearing, or indeed may help prevent such a hearing ever taking place. Thank you.
Thank you very much, Grace Maitland-Carter, and I hasten to add that our title in the Lion's Den was definitely not a reference to our last speaker. I'd only add one thought to what she has so eloquently set out, and it's this. As the solicitor appearing before the assessment officer, make things easy. And that's a general rule that's applicable, of course, to all court proceedings. I've found it very helpful to file a brief summary before beginning a presentation on behalf of the solicitor of what was done, possibly or in addition to a chronology. If we're talking about litigation or a complicated matter, don't leave it for the assessment officer to try to figure out from the bills, which often are not too informative in a coherent way, or for it to come out in the solicitor's evidence. As Ed had mentioned earlier, you don't have pleadings, you don't have discovery, so the assessment officer essentially has before him or her at the opening of the assessment nothing but the bills, the assessment order, and probably a copy of the appointment. And it's just bad strategy to let the assessment officer try to figure out what this case is all about while the solicitor's evidence is going in, perhaps not always in the most coherent way. It really never pays to get the assessment officer or any trier of fact annoyed with you. Thank you again, Grace Maitland-Carter. I think the next piece is mine also, according to my list. The last gasp, I'm not sure whose idea that was either, or appealing the order. I thought perhaps a better title for that might have been Hope Against Hope. You already have in the bound material my paper outlining the various procedures to be followed in appealing from the assessment officer's award. Perhaps I could just add a few highlights to what's in my paper. First off, if you move when you move against the decision of the assessment officer, it isn't an appeal, although everybody, including the judges who hear the motion, call it that. The Solicitors Act, which some people have said really ought to be called the Solicitors Fees Act, because there's absolutely nothing in it except comments and rules about the solicitor's fees, provides the authority for assessing lawyers' fees, and not always in the clearest language, I might add. For example, the Solicitors Act doesn't say anything at all about appeals. What it does talk about in subsection 6.9 is a motion to oppose confirmation of the assessment officer's certificate. Remember that an assessment is a reference, and there are two kinds of references. There's the kind of reference where the report has to be confirmed by a motion back to the judge who ordered the reference in the first place. And the second kind of reference is one where the report is confirmed by the passage of time, and those are in the rules. An assessment under the Solicitors Act is the second kind of reference. So the certificate of the assessment officer is confirmed in the same way as the report of a referee on a reference, which is by the passage of time, unless, of course, everybody consents, which they never do. That piece of apparently useless information becomes important in calculating the time from appealing from the assessment award. From moving to oppose confirmation. You see, I do it too. The thing to remember is that the time within which you must move to oppose confirmation, which is 15 days, doesn't start to run until somebody serves and files the report, or certificate as it's sometimes called. They seem to use both terms indiscriminately. There's a tricky little series of steps that have to be taken and that lawyers often overlook. First, a copy of the certificate has to be served on everybody who is present at the assessment. Secondly, the original certificate with an affidavit of service has to be filed in the court office where the proceedings originated. And it's only then that the appeal time of 15 days starts to run. If that isn't done, then I suppose in principle the appeal time would run forever. So it's good to keep that bit of information in mind, because if you want to uphold the certificate and you're concerned that there might be an appeal, then serve it and file it as fast as you can so that the time starts running. If you're moving to oppose confirmation, the next step is to decide what material to use on the motion. And of course the obvious things are the certificate, the evidence and the exhibits, the assessment officer's reasons, and so on. No need perhaps to talk about those. A point which sometimes arises is what other material can be used, can be filed on the motion. And I refer in my material to Rule 3901(2), which provides that evidence on a motion may be given by affidavit. However, the cases say that that does not give a party the right to adduce evidence on the motion to oppose confirmation by way of affidavit. For instance, you can't put in a solicitor's affidavit directed to the evidence that was adduced on the assessment. That's the case of Goring versus Walsh that's in my material. The other case that I refer to in my material on that subject is Goodman versus Davidovitz, which supports the principle that I've just indicated, but would allow some exceptions. For example, if the issue is whether the assessment officer exceeded his or her jurisdiction. The judge in that case held that where the affidavit concerns the very matter that the assessment officer had under review, then an affidavit would only be admissible if it met the test for the admission of fresh evidence on an appeal. And I can tell you that such cases are very rare. I should say a word about the function of a judge on a motion to oppose confirmation. The Deer Park investment case that is included in my material says that appeals from assessments, by which the learned judge meant motions to oppose confirmation, are categorized as interlocutory appeals. As I point out in the material, I don't think the judge got that quite right. But in any event, the principle has been accepted in other cases, so it's probably too late to do anything about it, unless it goes to the Court of Appeal. But what it means in practice is that motions to oppose confirmation of the assessment officer's certificate are governed by the principle in Marlene Investments Limited and McBride, which is included in my material, which held that an appeal from an interlocutory order of a master involving the exercise of discretion should be heard as an appeal rather than as a rehearing on the merits. And important for our purposes, there should be no interference with the order below unless it was clearly wrong. When will a court interfere? In 3 words, not very often. The cases are clear that a judge hearing the motion to oppose confirmation should not retry the matter or interfere with the result unless the assessment officer's reasons demonstrate, as the cases say, an error in principle, or unless there has been some absence or excess of jurisdiction or some patent misapprehension of the evidence. That's the Watson case that's referred to in my material. It doesn't matter that the judge might disagree with the assessment officer's findings or might have found differently. The judge is not permitted to substitute his or her views for those of the assessment officer, and that's Howe and LaBelle in my material. The toughest issue to succeed on this kind of motion is that the assessment officer was wrong on quantum. It's a settled rule, and innumerable cases have said this, that the court is only concerned with questions of principle and not with mere questions of amount, unless, unfortunately there's a saving grace there, unless the amounts allowed are so inappropriate or the assessment officer's decision is so unreasonable as to suggest an error in principle. So it always comes back to that issue of an error in principle. If you can't demonstrate that clearly to the judge, you simply will not succeed on your motion. There have been a number of cases in which courts have intervened on the ground that the amount allowed by the assessment officer was unreasonably high. And I'm glad to say there have also been some cases where courts have said that the amount allowed was unreasonably low, in which case the court may do one of 2 things. It may send the matter back for further hearing, or may itself restore the original bill or what it considers an appropriate amount. Having said all that, one might ask, and I think one of the questions that's been passed up deals in a general way with this issue, one might ask on behalf of the solicitor involved, is it worth it? Is it all worth the effort? And there's really no easy answer to that question. I've often said that it's one of the ironies of our business that the lawyer whose account is being assessed is always at a disadvantage. First of all, he or she has done the work, which is the subject of the bill. May have been paid, may not have been paid. Having already done the work, the lawyer, faced with an assessment, now has to do a whole lot more work preparing for and then appearing on the assessment. And as speakers today have indicated, that's not at all a simple or easy matter. And then, if there's a motion to oppose confirmation, the lawyer has to go through a whole lot more work to deal with that. And somehow, from the lawyer's perspective, there's something unfair about that, about being obliged to go through all this 2 or 3 times, potentially, in order to get paid or to hang on to the money that has already been paid to you, even though the lawyer's bill is upheld. He or she is not paid anything for all the work that was done to support the bill. We might perhaps get some costs, although the last speaker indicated problems with that, but even if you do get them, they usually aren't enough to cover your overhead. I don't raise this issue to rail at the assessment process. After all, the assessment officers and the courts are there to see that clients get a fair shake. They're also there, as some of the cases have said, to see that lawyers are remunerated properly for their services. I talked earlier about the stats that the ministry put out, about 80% of all assessments being originated by lawyers. Maybe they're correct, but we lawyers know that the profession is very much under attack these days. I'm sure you're familiar with the problems. Has a real estate deal gone sour? Sue the lawyers for negligence. Are you stuck in a bad financial corner? Sue the lawyers for breach of fiduciary duty. It's no wonder LPIC took such a bath. And it's the same with legal fees. Don't want to pay them? Ask for an assessment order and defer payment until next year or forever. I always tell lawyers whose clients want to assess their bills, you cannot win, because even if the assessment officer upholds your bill, every nickel of it, you are still out money because you're not going to get paid for all the work that you've invested in the assessment and a possible motion thereafter, not to mention the time of your junior, your staff, whoever else may be involved. That's not to say that you should settle every time a disgruntled client challenges your bill, although it often makes good sense to do just that. It's just that the assessment process can be so protracted and time-consuming that it distracts you from much better and more profitable employment of your professional time, not to mention your spare time. Some assessments have to be fought, of course, and appealed from, of course, because there will always be unreasonable or obstreperous clients who seek to take advantage. But it's often, as I say, a no-win situation and best avoided if at all possible. Thank you. The next part of our program, as you can see from the statement of claim, is a series of brief presentations by 5 lawyers who will talk briefly about, the headline says, challenging cases and situations in their particular area of expertise. The first, by the way, to just get our program into focus here, we'll hear these reasonably brief presentations by the various people. Then we will all be here for the question period. A number of questions have already been sent up in writing. We'll try to answer them, and we will certainly welcome and try to answer any further questions. If you have a question, it doesn't have to be written down. We take oral ones too. And now I'd like to call on Rodica David to lead off on the first leg of our challenging cases.
I would prefer to stand.
Yeah, certainly.
Thank you, Mark. I have a client, a young woman who came into me a few months ago. And she said to me, well, I have a matrimonial problem. My husband dumped me. And he's really a nasty, I won't use the word, but anyway, starts with a B. Of course, I want custody of my children. I really need very substantial support. I want to stay in my house forever, and I want a lot of money for all my property claims. I just assume my husband go away when it comes to the children. The thing is, I really don't have very much money. I really don't want to pay for this service. It's all his fault. I think he should pay for it. By the way, he's not really reporting all his income. He has all kinds of sources of income that you're going to have to get out. So I don't know how you're going to find this out, but I know he's got it. And I've led a very high lifestyle, so I really need a lot of support. So will you take on my case? Now, this woman actually has some very substantial rights. She herself does not have a lot of money, although perhaps her family could support her in the payment of some of the legal fees. She deserves to have good legal representation, and her case is very challenging. So I guess a family law lawyer can say to this woman, I'm not going to act for you. You go somewhere else. Or you can try to explain to her that legal services do cost money, that it is her obligation to pay you, that it could get very costly, and hopefully we'll have a good result, but we can't guarantee it. I spent a great deal of time with my client at the first meeting. Now, this is a real case. I've tried not to give you enough detail so you would know who it is, because I think probably she will assess my account, because now I've come to the point where, having expended a great deal of time and effort, she says, no, I don't want to pay. She's paid me some money, but I don't want to pay. She, of course, was one of the most demanding clients I've ever had. She calls every day, lengthy telephone conversations, doesn't want to pay for them. I've written her letter saying, we're charging you for this. But it really isn't her fault, and she doesn't want to pay. And I don't know how to avoid that. But I hope that my paper and my talk will give you a few tips as to how to protect yourself as best you can. Because not only the family law lawyer, but every lawyer has to protect number one, and you want to be paid for your services. If you put in the work and effort, which I know I do, and I look at faces out here that are familiar to me, and I know that you do. You put in the work and effort. You work till 1 in the morning when you have to. You get up at 6 in the morning to prepare. And you want to be paid for that, not for overtime, not for extra effort, just for the effort that you put in. Okay, well, how do you do that? The first and most important contact with your client is the first meeting. My meetings with my client, my first meeting lasts at least an hour and a half, possibly 2 hours. And I will review the facts in great detail with the client. And at the end of the meeting, or towards the end of the meeting, there has to be a discussion about fees. You start off with your retainer form, and I've given you my precedent. This is what I use. And I'd like you perhaps to turn to it so I can highlight some of the aspects of it. It is, I think, Appendix A. It's not necessarily the best form of retainer. I hope my clients have not complained that it's too complicated and they don't understand it, at least not yet. But who knows, maybe a client will make that complaint. And I listened with great interest to Assessment Officer Maitland-Carter's talk on the complexity of retainers. But as I say, I've been fortunate so far. There's a number of things that I put in there that I ask the client to read it in great detail, and I sometimes tell them, take it home. They always get a copy of it, but take it home before you sign it. If you have any questions, you ask me about it. I don't want you to sign this retainer form until you have read it and you understand it. And I do try to go over it with the client, or at least have a member of my staff do that. The first thing is just a general description of the services. And I put in sort of the whole ambit of family law, but not all of you are family law lawyers, so some of you might want to, of course, tailor your retainer form to suit your own area. I decided to put in things like limitation periods, just because if I miss one, this is not only for purposes of getting paid, but if somehow a limitation period is missed, you at least have a record that you've told your client. Of course, you have to do that over and over. The need for experts is point number 3 in the retainer form. In the most of the family law cases that we deal with in our firm, we have to have our experts. We have to have our forensic accountants. We have to have our real estate appraisers, our actuaries, and that's on the financial end. We also sometimes, of course, get involved with people such as psychologists and so on. Now, the next aspect of it is pointing out the fact that they're going to get periodic accounts. I call them periodic accounts. I don't know whether it does any good. I also have on the next page, item 7, the fact that each periodic account will be considered a final account. I don't think that does any good either. I don't know. I haven't tested it yet. There have been cases that clearly say that if you have a series of accounts in one matter, that the client is entitled to assess all of the accounts. But maybe this will help if you don't want your client to be assessing every account. It has never been tested. It may not work. So don't rely on that, but I don't think it hurts to have it in there. But with respect to new matters, as Assessment Officer Maitland-Carter pointed out, it is really important to send out final accounts and then open a new file if you have a fresh matter. Even if it's completing a trial and then you go to the appeal, open a fresh file and have a separate system of a separate accounting ledger for that file, and your chances of not having to go back to day one are far improved. Listing the lawyers and the hourly rates, that's very important, and I discuss it with the client. And also, if you're going to change your hourly rates, which you sometimes do. Actually, I haven't really increased my hourly rate for a few years now, but you do sometimes. Sometimes you decrease the hourly rate. Not often, but I think it's important to tell your client. Item 8 in my retainer form is something that I tell the client. I know that there's some difficulty with this sometimes, but I do tell them that if the retainers are not maintained, that we may discontinue service. Now, on that basis alone, we probably wouldn't, unless the client makes it perfectly clear that she or he will never pay you. But putting it in your retainer form, I think, helps. And also that you can deduct from any settlement. You have your authority right in your retainer to be able to deduct your fee from any settlement. The final aspect of the retainer form is that we do not guarantee the outcome. In family law, any lawyer that guarantees an outcome has got to be foolish. Do not give a guarantee of an outcome, and make that clear to the client that when you're giving a view, it's a view only, and there's so many variables that you don't really know what the outcome's going to be in most cases. And do not give an estimate of fees, because if you do, you may rest assured that if your client ever assesses your account, the first thing that client is going to say is, she told me she was only going to charge me $5,000, and you've spent $100,000 worth of time. So you don't want to be faced with that. If you don't want to send out periodic accounts, which is something that you might want to do for certain financial reasons. Let's say your accounts are, it's a very complicated matter and the fees are escalating at a substantial rate. You know your client doesn't have the money, but will get it out of a settlement. And this is not uncommon, particularly when you're acting for women clients if they're not really the income earning or the asset owning spouse. If that happens, if you render your interim accounts, you're going to be paying GST on every account. Then you're also going to be paying income tax, because you pay tax on your receivables and you pay GST on your receivables, not on money in your pocket. So what you can do as an alternative, which we do sometimes, to make sure the client knows what's happening, is we send work in process statements. They are not accounts, but they look like accounts. They detail the services, service by service, the dockets. We have a computer system in our office, and the dockets are reproduced with the time spent by each lawyer and the value of the time spent. So the client cannot come and say, my goodness, I didn't realize that so much work and effort had been done and so much time had been spent. These are a few pointers. I don't know how much time I have left, but I want to thank you, and I'll look forward to hearing any questions that you might have.
Good. Thank you very much, Rodica David. I'm not sure if all my panelists are here. Is Brian Schnurr here yet? Yeah, he's around. Good. There he is. There's the man. You want to sit or stand, Brian? We have chairs.
I do just want to get a glass of water. What I thought I would do is, just in a few moments, make some comments with respect to peculiar aspects of costs or different aspects of costs in estate litigation, the area that I have some familiarity with. And, pardon me, there are unique aspects to costs. I'm not now talking about a matter of assessing one's costs. I'm just talking about the disposition as to costs and therefore the approach that the solicitor has to take with the client regarding costs in matters of estate litigation. The primary unusual feature of estate litigation is an historical one, and that is that, as you know, in many aspects of estate litigation, particularly issues of challenging the validity of a will, there has been a traditional position of costs being paid out of the estate. Not restricted to challenges to wills. It applies often to dependent support matters and interpretation of wills and removal of trustees and variations of trust, etc. And it's important to know the limits on this because that traditional position has changed very much in that, as I point out in the paper that I provided, generally this idea of costs being ordered out of the estate, even where my client challenges the will and is unsuccessful and the will is found to be valid, a costs order being directed against the estate stems from two general principles. The one being that, well, the deceased is somehow responsible, at least in part, for the problem and for the litigation, and therefore it seems only fair and just that the costs, or at least a portion of them, be borne by the estate. And secondly, that the issue, particularly with respect to validity of a will, but also matters such as dependent support, are matters of community interest. In rem, if you like, particularly with respect to the validity of a will, and it is of importance to the courts and society that people not be concerned about coming forward and raising questions about the validity of a will because, oh my gosh, if I fail, I'm going to end up paying the costs out of my own pocket. Those have been the traditional reasons that the court has very frequently, over literally centuries, found that even in a case where the challenger is unsuccessful, the costs, if not solicitor and client, then party and party, or fixed in some fashion, be paid out of the estate. As I indicate in the paper, that approach has changed very much, especially over the last 20 years. The courts have been inclined, more so in Toronto in my experience than in other areas of the province, but particularly in Toronto where we have an estates court and therefore we have for the most part a limited number of judges who sit on most of the estates cases. The courts are much more inclined to test the question of disposition of costs by the same standards that are applied in other areas of litigation. That is not to treat estate litigation as necessarily being that unique. So that I've cited, for your benefit, should it become relevant to you at any time, in my paper, a number of cases where wills have been challenged and the court has either, in some of these examples, ordered that the challenger who is unsuccessful pay their own costs, that the challenger pay some portion of the successful party's costs, or the challenger pay full indemnity, i.e. solicitor and client costs with respect to the party that was successful. And as you'll see from those cases, not surprisingly, the court is moved very much by factors such as the relative merits of the case of the individual coming along and challenging the will. The courts react to the fact that we have too many cases of people simply coming out of the woodwork and deciding they're going to challenge a will, either more for emotional reasons than financial reasons, or, as is too frequently the case, because the lawyer they've retained has told them, well, you got nothing to lose, because if you don't get anything now, and you would get something if you're successful in challenging the will, and your costs are going to be paid out of the estate, then why not challenge the will? And that's the area where you and I suggest, have to be much more careful than perhaps solicitors have been in the past in advising our clients at the outset, where a client is considering challenging a will, just what the risks are. There have been too many cases, and I've seen too many cases, where someone has been advised that you have nothing to worry about. Worst possible scenario is that you fail, but your costs will be paid out of the estate, and therefore, again, you can go into the litigation with impunity. As the cases that I cite in my paper indicate, that isn't necessarily the case, and increasingly, if a party is unsuccessful in a piece of estate litigation, that party is going to be put to the test at the end of the day of justifying why they should not be responsible for the costs of the successful party, as would be the case in most other forms of litigation. Now, I've also made reference, I've spent most of the time in the paper addressing cases of challenges to wills, because those seem to be, or that seems to be, the category in which this arises, that is, this somewhat mythical belief that costs will always be directed out of an estate, and that seems to feed that area of litigation. But you'll note that I make reference to cases in the dependent support context, interpretation of will context, and removal of trustee context. Interpretation of will, you would think, is by and large a slam dunk. I mean, if I'm going to the court to interpret a will, surely that's the situation where most strongly I can argue, even if I'm unsuccessful in the position I'm advancing in court, that the will needs interpreting because of the fact that the testator didn't clearly set out his or her intentions. Therefore, the cost should be paid out of the estate. And that is usually the case, and with justification, in interpretation cases. But two situations I mentioned to you where that doesn't occur in the interpretation of wills. One is where somebody is pushing an interpretation where it really has no merit, where the position they're taking is so far in left field as to not warrant an interpretation. Parties have been denied their costs. And the second one, which is more problematic and directly of concern for you and for me, is where the problem has been the drafting on the part of the professional. So if you and I draft a will and we decide that we're going to include that wonderful provision, like to my children in equal shares per stirpes, and then no one knows just what the hell that means, and it ends up like many reported cases for interpretation, and sometimes the court goes one way and says that, well, by children he really meant issue, or the court goes the other way and says, well, he used children, so even though he said per stirpes, we're going to read it as per capita. If that ends up being interpreted, then the court, if someone is at least alert enough to include the lawyer as a respondent, is going to give serious consideration to awarding the costs or directing that the costs be paid by the solicitor who drafted the will for as a result of the negligent drafting. So even in interpretation, and by the way, there have already been cases that have gone before our insurers with respect to just that kind of situation, and I have one now where the costs of interpretation of a will, and it wasn't even that complex, it was an issue of the solicitor had drafted the will and provided that my entire estate is to go to my nieces and my nephews without naming people. And then the issue arose, did that class of nieces and nephews include just those by consanguinity, by blood relationship to the deceased? Or did it include a far larger class, those who would be not related, but be termed nieces and nephews by affinity, i.e. are the children of my wife's brothers and sisters, my nieces and nephews. They were very different groups of people, and that interpretation occurred out in Windsor, and the total costs as assessed on a solicitor and client basis for the 5 lawyers involved were $271,000. And now the beneficiaries, of course, are coming against the solicitor claiming those costs based on negligent drafting. Those are my comments with respect to costs in the wonderful field of estate litigation. The only other thing I would just mention to you, which is sort of on the periphery of the topic of this program, but at least close enough that I would just leave it with you, and that is that if you get involved with the area of executor's compensation, which is not, as I say, truly into that of costs, I just mention it because there is a relatively recent decision which seems to have changed the area, at least temporarily, of executor's comp quite considerably. And just make a note if you get involved with it in the next little while, a case as yet unreported, I don't think it's reported yet, called the Lang Estate, L-A-I-N-G, which is a decision of the Ontario Divisional Court, and it's under appeal to the Court of Appeal. And what it does is give a position of primacy to the tariff guidelines, as those of us who play in the estates area a lot like to call it, of the 2.5% of capital in and out and 2.5% of revenue and 3/5 of the annual average value of the estate as a care and management fee. The divisional court in Lang says that what had happened was a lawyer had claimed executor's compensation of just over $200,000, and after a trial on the issue of compensation, a court decided that no, his services as executor were only worth $75,000, and the lawyer appealed, and on a 2-1 split, the divisional court said that unless the estate is exceptionally simple or very complex, the tariff should apply. And therefore, the court reinstated the full $200,000+ for the lawyer. Now, as I say, the case is under appeal, but I just mention it because of the fact that, as far as I know, it hasn't been reported, and until it's dealt with on appeal, it has made a change, certainly, in the area of compensation, where generally the understanding has been that the tariff guideline is just that, a guideline, and you have to test it against fundamental factors and not just apply it in a set way. So those are my comments with respect to, as I say, costs and somewhat related matters in estate litigation. Thank you.
Thank you, Brian. Thank you, Brian. I'm now pleased to call on John Day, who will address us briefly on civil cases. That seems a bit of an oxymoron to me, John. I would guess they would be uncivil cases, wouldn't they?
Well, it appears that when they get into the assessment office, they mostly are uncivil, but we must remember that what the assessment officers see is but the tip of the iceberg, and all those that are in fact civil, normally you get paid and you don't have to worry about these other endeavors. Jack Weir in 1952 said, as he was addressing comments to the Law Society on costs, that unfortunately he was taking his the topic of his lectures from the Bible, and that he was afraid that the money was the root of all evil. If you look at the notes and that have been prepared for you and are in the book, and look at what has been done with respect to retainer and a reference through the cases that Harvey Spiegel has done for us, I think he's done a very good service to the legal profession. Certainly there's a great deal of unknown out there about what the Solicitor Act is really saying, what you can and can't do if you're trying to enter into an agreement that also involves litigation or matters that are before the court. So do look at that carefully, because I think it's a good service to the profession. I've never really understood what those sections of the Solicitors Act are purporting to set out in detail or to confine what you can and can't do. So do look at that. It's very helpful. I found it very helpful looking at it this morning, and I'm sure that you will. I don't want to talk on this topic in the sense of a review of the law. I think that's dangerous, and therefore if you're interested in this field and you've got a case in this field, do go to the other sources. Go to Mark Orkin's book. Look there. There's 83 pages in the solicitor and client chapter in his book, and I can't possibly in 5 or 10 minutes do justice to that. And as other people have written other topics, I mean, this has been before the Law Society for years, you'll see that there are seminars that have been presented here in years gone by, and those papers will be very helpful to you, as well as the Canadian Bar Association seminars. So do look there and get whatever comfort you can from these other lectures. Let me just start with one or two matters that I'd like to touch on, and that is communication. Communication also includes the financial. Rodica David this morning has given you a delightful answer to what you want to do if you want to get that financial information out there, but you really are not in a position to render an interim account. So take a look at that. I'm reminded that what Master R.B. Peterson said in his lecture notes in October of 1987 to the Continuing Legal Education Seminar for the Canadian Bar Association, and that was, he advised the people there that day that he had the experience that after a solicitor had given evidence in chief as to what, in fact, the solicitor had done for the client said words to the effect, "Well, now that I know what was actually done, I'm not objecting to the account." And I raise with you what could possibly have been the reason for so much mystery between that solicitor and client, other than the matter of poor communication. For heaven's sakes. So when you're drafting an account that you are going to send out to the client, take some time about it. It may well be the one that is going to be assessed. Prepare it accordingly. And as well, think about whether it's appropriate to send another reporting letter along with that interim account, pointing out what your original estimates were, why they are now wrong, what your future estimates as to the likely procedures are likely to be. You know that the guy on the other side has now become totally unreasonable. Well, if that's the case, no sense of you complaining to your other partners or to your secretary. Write a letter and tell your client that the other guy is out of control. Likewise, W.C. McBride, who was a wonderful individual, when commenting at the Law Society of Upper Canada Continuing Legal Education seminars here in 1983, said he analyzed his own taxation references for the first half of 1982 and found that the solicitor's bills were reduced in 3/4 of the taxations where the client appeared and contested the bills, and in half of those cases the reduction was at least 25%. So obviously, the message for you people out there is You've got to alleviate the need to have assessments by good communication. Now, what are we going to do? Are we going to proceed by action or assessment? And if you look at the case notes that are prepared for you by other people, you'll see that there are some boundaries in which you cannot sue. But there's a large area that's still open to the profession to sue for their account. And it may well be, by the time the provincial government's fooled around with the Solicitors Act and the Office of the Assessment Officer, etc., that may well be the end result of what everyone's going to do. However, when I started in the practice of law in 1974 in the city of Toronto, it was simply not on that solicitors would sue for their accounts. The Solicitors Act was there, the procedures were in place, and that is what we were expected to do. As the backlogs built up and the difficulties in the assessment office overcame us, some members of the profession sought to sue, some with success, some without success, because they didn't understand the complexities of the law and were suing in the wrong situation. So do be careful. But also remember that even as late as 1993, Mr. Justice Adams has indicated that really, because of the Solicitors Act, and it gives this profession a monopoly, nevertheless, we should look to the Solicitors Act rather than actions in proceeding against clients who have difficulties with our accounts. So just watch the case law and be careful. Serious allegations of misconduct. Mr. Justice Chadwick in 1991 sent a matter that was in front of an assessment officer on to a hearing in front of a judge. And what had happened is that the client, with respect to a matter that had originally been litigious, at the assessment of the account, started to raise before the assessment officer serious allegations as to negligence. The solicitors involved in the assessment got an adjournment and immediately brought an application to the court to have the matter sent from the assessment officer, who while appointed by the province to the position and had had some training, had no legal experience or background. He was not one of the individuals that you saw in the 70s that had legal education, was a master, and was also an assessment officer. And there, Mr. Justice Chadwick said, because of the serious nature of the allegations that were being made, it wasn't appropriate for somebody without a legal background to consider these sorts of serious issues. So he sent the matter to a judge. Now, you want to approach this with some caution and understand what may or may not occur. Obviously, if you're dealing only with an assessment, there is no power to deal with damages for negligence and those sorts of things. A judge would have those powers, but it seems to me that the judge would not have those powers in a simple assessment situation. But having got it in front of a judge, goodness knows whether the other side could then move to try and amplify the area, or worse still, institute a proceeding. So be careful. But certainly if there are serious allegations that are being made, it seems to me that you want those tried by somebody who has a basic understanding of legal facts and can make that determination. Bonus or premium. Given that there are 9 factors to be looked at in setting an account, I have trouble with the concept of bonus or premium. It is called that, certainly in the case law. Fortunately, Madam Justice Greer in the Equity Waste case that I refer you to says that it's not got to be part of the agreement up front, that in situations it is often dealt with at the back end after the result is known. So there's some help there, especially where the solicitor had made it abundantly clear to his client that he was not going to bill on a taximeter approach. with respect to corporate work and securities work and other work, you hear a great deal about value billing. And I'd like to see the members of the litigation bar get that concept into the case law, because I'm not so sure that what we're talking about here is premium billing or bonus billing. If you take all the considerations into account, and there's 9 of them, and if you've had good communication with your client and he's understood and you've given estimates, etc., only one of them is time spent. I mean, the monetary value to the client of the proceedings is equally as important, perhaps more important than time spent. And if you fairly balance the factors, I'm not so sure we're really talking about bonus billing. Fee estimates. They are important. In fact, the rules of professional conduct indicate that we owe a duty to our clients to give them a fair estimate of what the likely fees and disbursements are to be. That doesn't mean that they are, once given, that they're written in stone. Obviously, as matters progress, you're going to review your file and update your estimates. And that's all that anybody can really ask of you. And if you do it at the time that you interim bill, then I think you are very, very fairly treating your client and meeting your obligations to the Law Society. Contingent fees. An interesting situation. Ontario is the only province that in 1989 did not allow them. We've brought them in a limited sense in the field of class proceedings. And I am currently involved in a matter where there was a contingent fee that was entered into between the representative plaintiff and the counsel that was for a fee that was not a multiple of hourly rates. Mr. Justice Brockenshire had to look at the provisions of the Class Proceedings Act, Section 32 and 33, in coming to his initial decision. And what he's held is that the hourly rate by a multiplier is not the only contingent fee that can be entered into with court approval in this province in respect of a contingent fee, that any contingent fee is possible. And he came to this decision by rearranging certain sections of or subsections of the legislation. And I ask you to think carefully about this if you are at all inclined to take on a matter and draft a contingent fee arrangement between your firm and the representative plaintiff. Professor Watson's comments in October of 1996 were, query whether the interpretation of Mr. Justice Brockenshire is correct, although when I first read his decision, I concluded and wrote that he was clearly correct. On reflection, I think a case can be made that he was wrong, and me along with him. And the matter is currently before the Court of Appeal. The appeal is being perfected but not heard. If you're interested in delving into in a little bit deeper detail as to what's going on here, then I've given you the sites that will allow you to go and have a look at what the Ontario Law Reform Commission had to say about this and what the Law Societies had to say about this, and look at one or two other articles that I refer you to make up your own mind on what this legislation is really allowing you to do with your contingency fee. Thank you.
Thank you very much, John. I'm now pleased to call on Frank Bennett, who will give the last kick at the can when he deals with liens and charging orders. It sounds to me like unpaid fees are involved.
For those who are leaving, there's an extra page. It's up here at the top right corner. In preparation for this lecture, I've given you a draft bill of costs in a bankruptcy matter. And I was looking at it last night, and I thought you may want the answers to all those numbers there. So I typed it out last night, and here we have it today.
Let me get these out of your road.
Thank you, Mark, and good afternoon, ladies and gentlemen. Welcome to the wonderful world of legal fees and disbursements in creditor-debtor law. As a general rule, and the general rule usually sticks, it is exceptionally difficult to earn your fees in debtor-creditor matters. And secondly, it is exceptionally difficult to collect your fees once you've earned them, irrespective of whether you act for a creditor, a debtor, or the trustee or receiver. I take the simple position that most litigation that we have in the province of Ontario is debtor-creditor, whether it's family law, estate law, deceased estates, bankruptcy estates, immigration, criminal law. It ends up in debtor-creditor work, and debtor-creditor work means that you've got to earn your fees and then, of course, justify it to an assessment officer or taxing officer if it's in a bankruptcy matter. And that includes simple things like breach of contract, leases, enforcement of rights under PPSA, mortgage remedies, shareholder disputes, criminal law, construction law, and of course bankruptcy and insolvency law. So you're into a very difficult area whether you like it or not, and earning your fees is difficult with our laws in Ontario. It's difficult to earn because our laws in debtor-creditor in Ontario are very complex. They overlap, they're antiquated, and they need great revision. They need somebody to coordinate them. And as a result, you're putting in a lot of time, and you get abused by your clients because you're not sure what you're supposed to be doing. You get abused by the other side, the other lawyers, because you haven't conformed to your time periods. And of course, sometimes you get abused by the courts as well. So for all that abuse, are you going to get paid? Are you going to get paid at the end? It's difficult to collect, and it depends on which side of the coin or in the middle of the act for. If you act for a creditor, you may be spending good money after bad, and the creditor doesn't want to spend that money, especially in a collection lawsuit, or what the client seems to think is not a collection lawsuit, but an ordinary lawsuit that ends up to be a collection matter. So you're guessing initially at the initial retainer when you meet the client and spend the initial hour or 2 hours and go over all the facts in great detail. And as Ms. David says, try to get that retainer signed. And you have to sit back and you say, am I going to get paid? Am I going to get paid? Am I going to get paid for all this service? I mean, unlike retail stores where you can buy and sell clothes, ties, and shirts, the customer knows what they're getting. Unfortunately, in the legal profession, we're not quite sure what you're getting. You're getting a time and skill and knowledge, but are we getting the services that we're asking for? And in this area of the law, it is very confusing. So, if you have a single client who's a creditor, they come off and say this is a single, simple collection matter, which ends up to be disputed, and there you are in a disputed lawsuit and have spent a lot of time. You don't know where you're going. You don't have a roadmap. If you act for a client that has many matters, then you can make a deal, and the client is more forgiving and you're more forgiving. You communicate, as John Day says, with the client. I take it one step further. I say you not only communicate, but you care. You hold the client's hand. You have compassion for the client, especially when you have multiple clients that deal in collection matters, because that client is your lifeblood. So reduce your rates, be upfront. Or if you're going to increase them, tell the client. Show the roadmap to the client, because most of those lawsuits are going to be defended today. It's not like 20 years ago when the debt officer calls up and says you haven't paid your account, will you pay? And they pay. Today they defend. So if you act for a creditor, remember you're dealing with a creditor who's already lost the money and they want to recoup it, so they're not very happy about your bills if they're too high. If you act for the debtor, usually it's a one-time thing. It's robbing Peter to pay Paul. The client never has enough money, and you're going to be stuck. Maybe initially, after getting your first retainer, where are you going from there? You have to review the client's affairs, make sure that there's money coming downstream, or find out who the client really is. And that's a major problem we have as lawyers, of finding out who our client is, especially in debtor-creditor. Is the client who's the debtor coming into your office the individual? Is it the director? Is it the officer? Is it the shareholder? Is it the company? And who's going to pay your account? Is it all of those people? Is it going to be a third party, a spouse, who's going to guarantee the account? Find out who your client is, who your real client is, who's going to pay your bill. So from a debtor's point of view, be careful, because you're going to get burnt. You're going to act for the company, you're going to put in a notice of intent to defend, a statement of defense, and you go along merry way. You know the company's broke or going to be broke, so who's going to pay your account? The shareholder, the director, the officer? Everybody says, I disclaim. You're acting for the company. So be upfront with the client. Who's paying your account? If you act for the trustee or receiver, which most of you will not do, it is easier. You think it is? No, it's not. It's just as difficult as the creditor and the debtor side. Why? Because if you act for a trustee or receiver, many of them take it on, quote, contingency fee basis. They're not quite sure there's going to be assets in the estate. They're not quite sure if they're going to get guaranteed or indemnified by the principals if they take the assignment in bankruptcy, or they take it on behalf of the bank and the bank says, sure, look to the assets. And if the assets aren't sufficient enough to render an account, then you're not going to get paid either. So you have to look down the road. Look at both sides of the road to see, when you act for a receiver or trustee, are there going to be assets in the estate? Is there real estate? Is there something to sell? Is the trustee or receiver going to get a guarantee? Unfortunately, in bankruptcy and in court-appointed receiverships, you must tax your account. You must. In bankruptcy, they call it still taxation. In court-appointed receiverships, it's an assessment. And when you act for the middle person, not the creditor, not the debtor, when you act for the middle person, you get shot from both sides. The creditor says you haven't done your job and may be negligent. The debtor says you are negligent and you haven't sold the assets at fair market value. So you're going to get taxed or assessed from both sides. And both the creditor and the debtor are going to attack the trustee and yourself as solicitor to the trustee. So you say, why practice in the area? Well, that's where the clients are, that's what you are, that's what you're doing. So, apart from the retainer, the cash retainer, you look to liens and charges. Liens aren't worth the paper they're written on today. Possessory lien today, with photocopiers and Xerox machines and fax machines and email and copies, the client has all the papers. They copy everything now. So the possessory lien is useless. Charging order has attraction, and that's what you have to do. Ms. David's precedent retainer is great. Could go one step further and ask for a security instrument. In other words, if you're in a matrimonial love affair, warfare, then you should take a security interest in not only the judgment, but also in the equalization payment or whatever else. Because if the other side goes bankrupt, what then? You may be out of luck. Now, what I'd like to do is put on a couple of slides. If you can't see it on the wall, it's in the materials at the end. It's a good precedent. If you ever get involved in a bankruptcy matter for creditor, debtor, trustee, follow the form. The guidelines are out here. Number one is the estate number. It's not court file number, it's an estate. So everything is in that estate, and it's either given to you by the official receiver if you're in Toronto on St. Clair, or it's given by the bankruptcy office at 393 University now, and those are the numbers. It's always in the matter of the bankruptcy or in the matter of the proposal of ABC, or now and then in the matter of the CCAA arrangements. The third item is a block bill. If you go to the bankruptcy rules, you've never done a bankruptcy bill, there's bankruptcy rules behind the Bankruptcy Act, Bankruptcy Insolvency Act, and those rules are antiquated. Don't even look at them, because you get 50 cents for this and 25 cents for that and $1 maybe for that. So they're antiquated, don't look. Put it in a block bill format. You don't have to list all sorts of items, but if you're dealing with many different subject matters, sale of real estate, deceased estate, litigation, then put it down in block format. Put down the time, item 4, number of hours, then there's a multiple which extends it over to item 5. Item 5 is the taxation of account. You're allowed $50 on top of it. Item 6, disbursements. If the bills now are, because of the provincial tariffs, you have to pay $50 for accounts over $3,000, and you pay $25 for accounts under $3,000. Item 7 is the account number. If the account is under $2,000, your fees are going to be reduced by 1/2. That's in the Bankruptcy Insolvency Act. If your fees are below $1,000 or below $2,000, it's reduced by 1/3. And then the registrar in bankruptcy will tax it at that amount on whatever date. Number 8 is a trustee certificate. That's the client. And the client certifies that he or she has reviewed your accounts, they're satisfactory and fair, and puts in the amount after payment to secured creditors. So in many estates of bankruptcy estates, there's the secured creditor on top, and if there's no money flowing down, then there's perhaps no purpose in having your account taxed. Item 9 is needed because where the account is over $10,000, the registrar wants you to appear, and if it's over 10% of the gross receipts, you need inspector approval. Inspectors are like executors or trustees of a deceased estate, and they guide the trustee in bankruptcy. So you can have anywhere from 1 to 5 inspectors. You need a majority of inspectors to sign the account. And the last item, item 10, is you don't have to serve anybody. If nobody's going to oppose, if the trustee accepts the account the way it is, the inspectors accept it, then the trustee waives the notice of time in place of the taxation, which is usually in Toronto on Thursday afternoons. So that's a review of a bill of costs, just in case you ever need it. Now, I guess I have a couple of slides I'd like to go over that relate to general. This is not materials. I've been fortunate, I guess, over many years of practice to listen to clients. I guess I care a lot, and I found out that when I hear about clients, and I guess it applies to the whole day program, common clients' complaints, and I hear it even now, I hear it every day, and you've heard it, I'm sure, many times as well. They overcharge, they don't give you a quotation. And if there's a quotation, the amount of the bill exceeded the quote. Well, in creditor-debtor law, forget everybody else's. I don't know where I'm going when a debtor comes in and he wants to put in a defense. I don't know how long it's going to take me. I can't guesstimate. What it's going to cost. And the reason is, in debtor-creditor law, you're all over the place. You're zigzagging all over. It's not like doing a will, where you want a simple will, or you got a house sale, or you got a deceased estate with no complications, or you got a simple divorce. You can more or less package a fee. So if you're going to quote, be careful, you're going to get burnt later on. So overcharges, it's like sending your car into a garage mechanic and you open up the hood and say it doesn't work. The next thing you know is you pick it up at the end of the day and it costs you $1,500 and you say, what'd you do? And they show you all the parts that went into it. Same thing. Well, clients are no different. They want to know. So be careful on a quote. Unauthorized personnel, client hires you. Not me, not him or her, hires you. And when the bill is presented, they got 5 other people on the bill. And the client is obviously upset. You didn't tell the client that there's going to be paralegal work in there, that there's going to be a senior solicitor, that there's going to be outside counsel. Talk to the client. Communicate. 3, amounts charged don't correlate to the hourly rates. The bonus factor, the contingency, the value billing. Be upfront. If you win the case, you want X dollars. If you lose the case, my hourly rate is this. It's a multiple times that. These are the people who are involved. Lastly, inferior quality of services. Assessment officers see this all the time. I see it all the time. Reviewing too much. Too much reviewing. Reviewing. Too much discussing. You see all these entries about discussing. Too much researching the law. You're supposed to know the law, and if you're a specialist or an expert in the area, you're supposed to know what the law is. Even I don't know what the law is. I have to look it up. I'll put down a very little amount of time unless it's a complicated problem. And when you see the amount of time in there, they could write books. I did. Other people have. Simply not knowing. Don't be embarrassed that you don't know. Call your friend. Call your classmate. There are many mentor programs, not only with the Law Society, but also with the CBA. Walk down the hall if you're in a large law firm. Ask someone. And if they don't know, then there's a problem. Ask another person, then there's a problem. Simply not knowing what to do and how to do it. You have to learn. But you can't expect the client to pay for that learning, whether it's in debtor, creditor, or any other matter. And the last slide, please. In my area, you get involved in complicated estates, and you never know who you're acting for. Item 1, newly incorporated companies. Who do we act for? The shareholders, the company, both. You're running into conflicts of interest and duty, and of course, who's going to pay you? Secured transactions where the secured creditor imposes the account on the borrower. Banks do it all the time. Who's paying for it? The secured creditor then debits the borrower's account, and the borrower screams and yells that they debited the account, and there's a direction to pay. It's too late. It's gone. 3, contingent plaintiff's work. Personal injuries. State work. Who's responsible if the plaintiff loses? Are the disbursements covered? Is there a base rate? Lower your rate. Be upfront. Agency referral work. Who's the client? Is the lawyer the client? Is the accountant the client, or is it the real client? Who's paying your account? And lastly, foreign clients. Overseas, foreign language, a lot of problems. Misunderstanding. Don't misunderstand. Communicate. All what you've heard today is communicate, care for the client, and you won't have these assessments. You really won't have them. You'll stop working. You'll stop working. Thank you.
Thank you, Frank. And in the time that we have left, we'd like to answer as many questions as we can. Perhaps if all my panel would come up and join us. John, thank you. Brian and John, I think we'll find chairs. I'll stand if necessary. Thank you. We'll be here all afternoon. Everyone on deck? Thank you. I should point out that an awful lot of these questions seem to be addressed to Assessment Officer Maitland-Carter. I'm not sure what the significance of that sudden popularity is, but thank you. Perhaps we could maybe I'd just like to draw one blind. Very good question addressed to our assessment officer. It's a multiple part question. Maybe we ought to do this one at a time. Pierre Trudeau used to be awfully good at answering those questions. He had about 6 parts and he kept them all in his head. I can't do that myself. First part, how do you get on an A list?
Well, I think the key to getting on the A list is to know about it. And those of you here today know about it. And everyone else doesn't seem to know about it because no one at the assessment office tells them, not our office, but where they book them. This is not being told to the people who are applying. This is very upsetting to us, and I know Master Clark is very upset about it, and I think it's simply some kind of procedure that this business plan has put into effect, hoping that people on the B list, that somehow they feel that 50% of these matters will somehow go away if they're put on the B list. So if you want to get on the A list, just simply insist that you be on the A list, that if there are no dates, then how can there be more dates? And yesterday, after an endorsement I gave to a matter that was before me on the A list, but I advised them about it, the scheduling person from 393 called me and said, could I have more dates? We have no more dates for the A list, and I gave him dates in November. So this assessment is now on before me for 3 days on the A list in November. And if you insist on the A list, I think that's, knowing about it is the key to getting on it.
Is the idea that the B list then is sort of, if the A list collapses because it settles, then you can't?
Yes, yes.
You're likely to get
Yes.
an earlier date if you accept the B.
Yes,
Okay.
yes, and I mean, sometimes it works very well, and as you know, on all the court lists, they can be collapsed, and the B list is there waiting to go, and they go on, and this can be great if the B list, if you got your date a month later, this can be great. The tragedy is that often matters on the B list now are matters that started 2 years ago and have been adjourned for what reason or the other, and then they've got their act together, they're ready to go, they've got all their witnesses, they get on this B list, and then everybody shows up and they can't get on. So please ensure that somehow you're on the A list, and if they can't accommodate you, I think that this is don't say I said so, but this is a good reason to complain to the court office, because I recently had a number of people show up from Hong Kong, and a man, his wife, some of the family, they arrived for an assessment. They came in for the assessment. They were on the B list, and luckily I think we pre-tried it or did something, because this man simply couldn't come back again. He was going to be in that new provisional government that the China was putting in. So it was just horrendous, and it's very important, if there are witnesses and a lengthy hearing involved, that you know that you are not on the B list.
Thank you. Here's an estate question for Brian Schnurr. In estate matters, is the retainer with the estate or with the personal representative? And supplementary question, if we act for both, should retainers be obtained from both?
Okay, I assume what the question is getting at is whether you're acting on behalf of the estate, or you're acting on behalf of the personal representative in a personal capacity. Because remember, of course, there is no such thing as an estate as an entity. There's only the personal representative of the estate. So there's no question that you're retained by the personal representative of the estate. The question is, down the road, is it the personal representative is the personal representative able to pay your fees appropriately and properly out of the estate, or do they come out of that person's pocket? And it depends upon the nature of the action. The important thing is that where there is something going on, some aspect of litigation where there could be personal liability on the part of the personal representative, and somebody may be arguing that that person has to pay the costs him or herself, then you have to make it clear at the outset that that person may be personally responsible for your fees. For example, if you're retained by somebody to pass accounts in an estate, well, of course, you're being retained by the executor, by the personal representative, in the context of that person's fiduciary role, and part of his responsibility is to pass accounts, and therefore there's little question that those fees will be paid out of the estate, unless something horrendous comes out, such as dishonesty or what have you, at the passing of accounts. If there's an application to remove a personal representative and replace that personal representative with somebody else, and there's an allegation that that personal representative has acted improperly, conflict of interest, self-dealing in some way, then you've got to point out to the personal representative at the outset that, yes, you're being retained to represent John Doe, estate trustee, and John Doe, estate trustee, has every authority to give you a retainer out of the estate funds, etc. But the judge may decide at the end of the day that John Doe, estate trustee, messed up the estate, and didn't just mess it up, but did it in such a way that he should be responsible for his own costs. So bottom line is, you're certainly being retained by the estate trustee, but if there's an element to the litigation such that that estate trustee may be, or at least it may be argued that that estate trustee should be responsible for costs at the end of the day, that has to be drawn to the person's attention at the outset.